Runnymede, where the barons signed Magna Carta. June 1215. It was here, over 800 years ago, that the rule of law was recognised within one of the founding stones of the Constitution. It was here in June of 1215 that the barons, who had then been in rebellion, met with the king and he, with great reluctance, acknowledged that he was subject to the rule of law along with those that he ruled. In doing so, King John recognised that no man, including himself, is above the law.
Ladies and gentlemen, we will shortly be arriving at Colchester. Changing for services to Colchester Town. On behalf of Road Anglia and your train crew, I'd like to thank you for travelling with us this afternoon. Your next station stop is Colchester.
John, you've been kind enough to supply me with a copy of your book entitled simply Article 29, Magna Carta, 15th of June 1215, Runnymede. I understand from what you've told me previously that this book shares, along with 8 other titles, that's 9 titles in total, a very rare honour in this country. Would you like to explain for the benefit of our audience what precisely that honour is?
On the instructions of the then Attorney General, Lord Mackay Crashburn, back in '95, I wrote a book detailing how I proved the validity of Article 29 of the Magna Carta in the Royal Courts of Justice on the 2nd of February '95. But I turned myself in my own publishing house. But when I went to a national bookseller and asked them to sell it on my behalf, they told me I was on the blacklist. And I said, what blacklist? They said the Home Office keeps a record of all the books they regard as subversive and must not be sold to the general public. There are 9 titles on it and yours is one of them. And we had a talk about that, and he said, John, you must not sell this. You must not even try to sell this on any form whatsoever. This is why I'm not wired. Everything on my farm is 50 years old, from snail mail. If you try and do it in any form whatsoever, even give it away, you'll be taken and imprisoned without a trial, and they may throw away the key, just disappeared. So with effect from the 26th of March 1996, I was hauled off at midnight to become like a modern day Edmond Dante in the Chateau d'If, Count of Monte Cristo, in the English style of extraordinary rendition, like Guantanamo Bay. And now I'm in my 22nd year of having all the knowledge that in that book that I've talked about, still sealed up and unable to sell it.
And is it correct to say that you have not been, for this reason, amongst others, you have not been able to share this information previously with anyone via the internet?
I must not do anything. I gave some away, but basically, if people, I mustn't give it away or sell it or do anything at all. Otherwise, I get imprisoned without a trial.
So, in 1995, you appeared before the Court of Appeal.
Yes.
Please tell what happened during that appeal, and in particular when you were given judgment.
Well, I went to the Court of Appeal called 70, I think I remember, on the 2nd of February 1995, where I'd taken the Freemasons and 300 lawyers because they were hiding evidence on a court order concerning the education of my young son. That's why this is, everything in this action is under the Children's Act of 1989. All the details sit in my book, by the way. But, and as a result of that, having been given the judgment that was a historical groundbreaking judgment, I went down and sat in the cafe at the back of the Royal Courts and tried to write up my notes. And a man came up to me and saying, "You're John Coultham, aren't you?" I said, "Yes." But he said, "I was in court when you were in front of Ward and Russell." I said, "I knew the court was full, but sitting up front, I'm all alone." So he said, the word had gone out that a private citizen had accessed the Court of Appeal and was taking the Masons and 300 lawyers, and we thought this might be interesting. When you opened up, I said to my friend, "This man knows what he's talking about." He replied, "Yes, but can you see the judges have turned the microphones off, covers over all the other recording machines. This looks a bit nasty." He said, "You gave the finest speech I've ever heard in a court, and a wonderful judgment, proved all 13 points. What did you think to the judges?" I said, "They seemed friendly." "No." I said, "Call me John," I said to him. "They were looking at you with awe. They had a man better than they were in front of them, and they knew it. I'm a QC. You gave the finest speech I've ever heard in a court. And remember, John, you aren't a lawyer, you are a fruit grower," which made it all the more wonderful. As long as I live, I'll remember that speech. And I came down to shake your hand. When he left, I started to cry. A girl saw me, came over and said, "What's that man said to you? I'll speak to him." She came back. 2 of the top QCs in the country. He said he left his friend in shock, saying over and over again, "I can't believe it. What a speech. 55 minutes. And all ad lib. All ad lib. What a speech." So I told my friend, "I'm going down to shake this man's hand. Do it for me as well." He left him still exclaiming, "What a speech." I was crying for sheer happiness. And I had that said to me by one of the solicitors from the Norton Rose Group. The same sort of thing. And that's what happened in court. And but they turned the microphones off, remember. That should not happen in courts. With privilege defined, that would never be allowed to happen. At the same time, if they give verbal judgments in a civil action where you'll defend yourself, then they will have to get everybody to sign, you will write it down and other parties will write it down, and the judge will have the legal duty to sign that as a true record, so there will be no problems if you ever go to another court.
What do you believe the reason was for turning off the microphones and the tape recording equipment during the live delivery of oral judgment?
Well, I can only put it down to the fact that maybe the Masonic attitude. I do know that at the same time when I was going through the courts, I was dealing with, I think it was a chap called Freeman, who is a MP for Sunderland, who was doing a research on Freemasonry in the judiciary. And he asked me for my assistance because I've been in front of about 20 judges. And I said, I think that probably every 12th judge, and we're talking about mid-90s by the way, is probably a Mason, and another one might be married or married one, because remember I said there are ladies only lodges. And remember I said it only takes one judge to mess up a case. But this won't happen if you're defending yourself and you've had privilege defined. So when you're defending yourself, that will clip the wings of the Masons and clip the wings of anyone who wants to turn the microphones off. You'll outrank them straight away. You'll get nice, clean justice, which is what it should be.
Did you ever request a copy of the transcript of the judgment of the Court of Appeal?
I've got a copy of the transcript of the judgment, which lasts for 26 minutes, but the verbal judgment only lasted for 11 minutes. And the verbal judgment was the one that the lawyers came to congratulate me on. The written transcript is very anodyne, and if you read it, it sounds as though I shot down in flames and lost everything. But in the verbal judgment, you'll see that I got all 13 points proved, but I got the one that mattered most of all, which was Marsden in 1940, because I was dealing with a court order relating to my son. If they don't understand Marsden in 1940, that's their problem, mate. Sorry. Marsden in 1940, for anybody who knows, is mandatory on solicitors and barristers and judges to assist in obeying. And the Masons were hiding evidence related to my young son, and so I rolled up all 300 lawyers in one hit, and the Masons took them into the Court of Appeal and got the judgment that I was hunting for. And that judgment is sitting there in my book, which has been on the blacklist ever since the 26th of March 1996. So I've been, it's a bit like, as I said, a bit like Guantanamo Bay, but they were, the terrorists there were for assuming they were terrorists to an anarchy. I've been put on the, in Chateau d'If, the English style of extraordinary rendition, for proving the basis of the Magna Carta, as written and quoted, was actually a valid legal document. And I've been punished for proving it.
I shall now read from the actual judgment handed down by Lord Justice Russell on the 2nd of February 1995 in the Court of Appeal. The relevant paragraphs as follows, which are not to be found in the official Crown copyright transcript that was provided to you on request later. The relevant paragraphs are as follows. The Masonic Trust and Speechley Bircham solicitors were clearly at fault in view of the legal rights of the father not to give him immediate knowledge when this grant was awarded of all material facts and who has suffered severe damage and distress from this breach of non-disclosure of those documents. John Colthorpe entered into correspondence with the Masonic Trust for access to the files relating to his son, and as a result, Speechley Birchlam, solicitors for the Masonic Trust for Girls and Boys, in their letter of 6th of April 1994, nearly 2.5 years after the date when they and the Masonic Trust had had a legal duty to inform Joe Public of the extent of this award, endeavoured to explain that the Trust existed for the relief of poverty and the education of families of former Masons, and that this was a discretionary grant up to and maybe beyond his son's 18th birthday. The Masonic Trusts were clearly wrong in these dealings with the mother, acting alone, and it is also wrong of them to argue that they did this because the father is not a Mason, because the father is not a Mason, and arrangements should have been made by the Trust for Speechley Bircham to have supplied enough evidence to the father before the hearing of 7th of May 1992. Lord Justice Ward concurred. Well, as you've very helpfully and clearly described, not only were you taking an immediate contemporaneous note of that judgment, but you also, immediately after the hearing ended, you repaired to the cafeteria within the main cafeteria within the Royal Courts of Justice precincts and promptly took it upon yourself to write up your notes of the hearing and of the judgment. There can therefore be, which you verified by means of affidavit many years ago now, there can therefore be very little doubt as to what your immediate and contemporaneous record note of the judgment was. Equally, there can be no dispute as to what the official, allegedly tape-recorded Crown copyright transcript of the judgment states, and it states none of those things that I've read out in the relevant paragraphs which appear in your book and you noted at the time. Can I take it from that that the allegation is clear that Lord Justice Russell and Lord Justice Ward falsified the record of their own Court of Appeal judgment?
That's correct.
Thank you.
No free man shall be taken, imprisoned, stripped of his rights or possessions, outlawed or exiled, or in any way ruined, nor will we proceed against or prosecute him except by the lawful judgment of his peers and by the law of the land. To no one will we sell, to no one deny or delay right or justice. Clause 29, Magna Carta 1215.